not to make police more autonomous, but to see that today the weaker section of the society, the marginalized section of the society, these are the people who need police. The powerful doesn't need any police. The wealthy person doesn't need any police. The police acts in there and enforces the rule of law. And that will only happen if some of the basic reforms are undertaken. It is a fundamental, actually the reform is a misnomer. What is happening, the fundamentals are not functioning. I mean, next, the thing is, next level reform. Now, next level reforms, where are the reforms? The fundamentals are not functioning. And these are not reforms, these are fundamentals. And those, the system has to be put back on the rail. It's no longer on the rails. It's no longer on the rails. And I think it is, unless we accept that fact and deal with these fundamental things first before we undertake the reforms in general. And there, I think, again, here the directives of the Supreme Court, which were given in 2006, 8 years have gone, and little or nothing has happened. And I think there is something we are Prakash Singh is celebrating a Police Reforms Day on the 20th. And I mean, he is holding a demonstration on Jantar Mantar Road. And he is asking me also to come. I said, we have reached that level. We have reached that level. To get police reform, we have to hold a demonstration on Jantar Mantar. Where are we heading? Where are we heading? I think I've completed my 15 minutes, and Mr. P P Rao is a very tough taskmaster, I know. And so I don't want him to say anything more. But if there is any questions during question and answers, I'll be very happy to answer them. Thank you very much.
Friends, you have heard the voice of experience and maturity. One common factor which I noticed in Mr. Dharamvira, who headed the National Commission on Policy Reforms, and the distinguished speaker, Mr. Ved Marwah, is both of them after retirement held the high office of Constitutional Office of Governor of the state, and with distinction, without nobody questioning, as we find questions being raised recently when somebody was appointed as governor. Now, second thing I want to mention is this, before I call upon Mr. Shekhar to make his presentation. As he was addressing, he mentioned money power, muscle power. Way back, shortly before he became Prime Minister of India, Atal Bihari Vajpayee, one of the highly respected statesmen in the country, he delivered the 13th Deshraj Chaudhary Memorial Lecture in Delhi on democracy. He mentioned the same thing. He said, our democracy is, the electoral system is dominated by money power, muscle power, caste and community considerations. Second thing he said was, persons who do not have any ability or equipment, they are entering politics with the idea of becoming MLAs, MPs, minister. And what for? To serve their own interests, not the interests of the people. It was excellent analysis of the way our system is operating. But the pity is, during his time, National Commission to Review the Working of the Constitution was constituted by him, with the great Justice Venkatachalaya as the chairperson. Very eminent persons were their members. They made very excellent recommendations, but they are yet to be taken seriously and considered. Problem is known, suggested solutions are available, but there is no will to reform the system. Dharamvira suggested you separate this investigation wing from prosecution wing, make it independent investigation. If there is independent investigation, crime rate would not be so high. Second aspect, after investigation, you have to follow it up with prosecution. What kind of prosecutors you appoint? On what considerations? It is here lies the weakness in the system. If every public office is held by the most incorruptible, honest, efficient officer, things would automatically change. Not only independent judiciary, the powers that we do not want any independence anywhere, not even independent civil servants. This is the system. And just one more thing I want to mention, and then I'll call upon Mr. Speaker. As I was mentioning about plum posts being given to persons from nowhere who appear from nowhere without background, I was reminded of a small incident mentioned by Mr. T.S.R. Subramaniam, former Cabinet Secretary, in his book, Government of India, something like that. In that he says, one secretary to government in UP mentioned to him, he said, my minister is extremely busy with important matters like posting, transfers, appointments. All minor things like policy making, etc., he leaves it to me. So I attend those minor things, but he's busy with major things like appointments, transfers, postings. This is the level to which you have descended. And to reverse the system is not an easy task. Now I call upon Mr. Shekha, and he is a person, a rising star in the Supreme Court Bar. He is Vice President currently of the Supreme Court Bar Association, with potential to become President one day in the not too distant future. Now Mr. Shekha, he will present to you his views on commercial litigation.
Thank you, sir. Respected Mr. P P Rao, Senior Advocate and Associate President of our association and the Chairman of this session, Mr. Ved Marwah, former Governor Manipur and retired Commissioner of Police, Delhi, my close friend, Mr. Prashant. No doubt he was not supposed to speak, but he is one man who fits into any session. Because I have seen in the international session also, whenever there is somebody missing, they always used to search for Prashant, and Prashant was always there. At least I had two such experiences, one in Singapore and another in Korea. Then my friend Mr. Roshan Lal Jain, who is the coordinator of this session, Mr. Anil Divan, our respected President, Mr. R.K.P. Shankardass, our President who will be there after 6 o'clock, and Mr. Venkatramani, Mr. K. Bhat, and there somewhere in the corner, Priya Hingorani, who is there, and all my colleagues, including Mr. Prasad, who is here. Good morning or good afternoon, and welcome to this session. The topic of this session, there is a main topic and subtopic. I thought on the main topic, it was the prerogative of the chairman to address, but somehow I am trying to find a small place and try to address for 2-3 minutes on that. That is mechanism to bring efficiency in justice administration system. Even though I'm supposed to speak on the subtopic, that is reduction in cost can bring about efficiency, efficient outcome in commercial litigation. I'll speak on that subject after a little while, but I thought whenever a person like me gets a platform, should use that to speak from the heart and being part of the system, and the subject being so dear, I thought I can take that liberty with the permission of the chair. Just for 2-3 minutes, sir, I'll speak on the main topic, and thereafter I'll proceed on the subtopic. Mechanism to bring efficiency in justice administration. How do I perceive this particular main topic? How do we bring about efficiency in the justice administration? To me, there are 4 bullet points on which, even though there are many, but for me, I thought it was 4 on which I think if we concentrate, I think 60% of whatever the deficiency we find here could probably be solved and we can run the system better. The first is to bring quality and efficiency in the system. When I say quality and efficiency, both are interchangeable here. Quality means quality of the stakeholders in the system, both lawyers and the judges. I need not say anything, the kind of quality of judges, because probably I don't know whether I'm qualified to speak on that, because there are eminent seniors and seniors in the profession, but definitely about quality of lawyers. I'm little disturbed these days that we get a lot of interns, we get a lot of youngsters who come and join our bar, join the chamber. Most of them, they think that it is a 10 to 5 job, which is not so. I remember during our tenure, I think Venkatramani Saab will also remember, when we did our juniorship, when Venkatramani Saab did with Mr. Rao and I did with Mr. M.K. Ramamurthy, we used to go at 7 o'clock in the morning and we used to come only at 11 in the night. We have never seen sunrise and sunset at any point of time. And the new kind of research material or the infrastructure which is available, were not available. We have to sit with the AR digest, we have to sit with the entire AR books and try to find a help to seniors. So my request to the youngsters is, please, to help the system to grow, you must improve. I'm not making a complaint, I'm only just suggesting. There is no complaint, because like I know some of the youngsters would say, sir, you have grown too old, you belong to the old system. So we know how to handle it and we have been handling and we will do it. So you don't worry about it. But it's only a request. Sir, please, for God's sake, bring about a good quality. That's how we can improve the system. The second point on which I wish to address on this main topic is the infrastructure development and better management with simplified procedure. When I say simplified procedure, we find most of our procedural laws, whether it is CRPC, CPC, or even for that matter, the Evidence Act or anything, it's all, no doubt it is time tested, but it's so old. I think we need to have a relook into the whole thing. In fact, the other day when the law minister was speaking, he said that he is trying to get most of the laws which were enacted prior to 1947 repealed because they have become redundant. So, it's not only that, sir, those laws which were made prior to 1947, they need to be repealed if they have, probably they don't serve any purpose, but even the present law, if they have outlived or they don't suit the system, I think we need to have a relook. No doubt you may say, sir, the Law Commission is doing that. Yes, but most of the report of the Law Commission, we know what happens. Ultimately, it's never implemented. It just go into one of the racks. Maybe it finds in my law library for some of my future references or whenever I have to make my submission in the court. As far as infrastructure development is concerned, I'm very happy that we have come a very long way. We have computers, we have so many other things, internet, which were not there during our time. Definitely there is an improvement, and I would say definitely it has added to the efficiency in the system. And as far as better management, well, better management can be by appointing better judges, good judges, more judges. Because very rightly, as Rajiv Datta very rightly pointed out, commenting on the Chief Justice, that we have so much of arrears. Yes, we have so much of arrears. But at the same time, do we have so much of judges? Because whenever the judiciary or the judges or the Chief Justice go to the government, they always say, because I'm told in one of the informal meeting which we had, that for having one judge, a high court judge, the government has to spend on the salary, the staff and other things, almost around 15 to 20 lakhs per month. So the government says we are not in a position. So that is also marring a scope for us in improving the system, so the government must look into it. The third point on which I wish to stress, because there are 4 points, the third point is we have to identify the people who are responsible for effective administration. I have identified 4 people or 4 stakeholders in the system. The court, including judges, the lawyers, the government, and the litigant. Having identified these stakeholders, I definitely wish to dwell on these 4 participants when I address on my subject, which is a subtopic. So I will leave it at that, but only want you to remember that these 4 stakeholders play a very active role in the efficiency in the system. The last, and not the least, we have to build confidence in the system. This can be brought about by impartiality and independence of the court. We have been time and again talking about the independence of the judiciary. Today in the headline, the newspaper carried the Chief Justice's speech. He very rightly said, independence of judiciary is so dear to us that at no point of time we are going to compromise. I will never compromise, nor will I negotiate. That was the subject, the punchline which he used. Yes, we do appreciate, sir. That's in fact is one thing, because the impartiality and the independence will bring in about confidentiality in the system. And the confidentiality in the system will help in running the system efficiently. That is what I feel. Because if there is an impartiality in the system, we know for sure that when somebody goes to the court, because why somebody wants to go to the court? He goes because he wants to get justice. But suppose he feels that the entire system is so fixed, or the litigation is so fixed that he is not going to get any justice, I don't think any litigant would like to go and waste his time by going to the court. The next factor is time factor, which is very essential in our system. I will definitely dwell on this while I am speaking on my topic. So these 4 points goes in improving the efficiency of our justice delivery system. The next topic, the subtopic on which I'm required to speak. Bullet points I've given. Now, the subtopic on which I'm supposed to address is reduction in cost can bring about efficient outcome in the commercial litigation. In fact, what I have spoken just a while, all those points, bullet points, if incorporated, probably the justice delivery system on the commercial litigation side would bring about efficiency. But since I'm required to speak only on one aspect of a litigation, that is the cost factor. So I'm going to touch only on that, not on the other aspect. Again, I have here 5 bullet points on which, see why I'm saying points, because I don't think this is a session where I need to speak and speak, because I can keep on speaking, you can keep on hearing as long as you don't get tired. But I would like the audience to interact with me and also the others. When I say this, question and answer, because we would be able to evolve a new mechanism, a new thought process, which would definitely help us in improving the system. So when I say 5 points on this reduction in cost, the first point which comes to my mind before we start on this commercial litigation business is, before a case is initiated on the commercial side, this can apply even to the other branches of law or litigation. Before a case is initiated, an honest opinion should be sought about its strength and weakness of the case. In fact, it's in the recent past, or maybe even a little earlier, we have found that the courts are flooded with litigation, whether they are good or bad. Let me tell you a very interesting situation. On the commercial side, when a notice was initiated by the claimant to the opposite party, the opposite party came to me and gave their comments to the notices and claim. I found that my client had no case whatsoever. I told him, better thing is to settle. But the gentleman was so commercially minded, because what he was to pay at that time, 1980, was around 10 lakh. He said, sir, today, if I accept the claim, I have to make the payment immediately. I would deny everything and I will go to the court. I will at least get 5 to 10 years. By the time probably my financial position will improve and I'll be able to pay. That should not be the mindset of people. That's what unfortunately has been happening. So any honest opinion given by a lawyer or an advisor must be taken seriously, and probably that way we will reduce not only the litigation but a cost in the litigation, because it is quite possible that if you accept the other side claim, there may be other claim which will come at the time when the case is initiated, probably will not arise, like interest, or maybe the other inconvenience like cost, or maybe even on the claim made there could have been a settlement. So in this way you can reduce the cost of the litigation. So a person who goes to the lawyer must take the advice seriously, must know his strength and weakness, and must proceed. The second thing on which I wish to say is, before we decide, suppose the first process is over and the lawyer advises that yes, you have a 50-50 case or maybe 60-40, then you must work out the balance sheet as to what is going to be the cost involved if the litigation is taken out, what is going to be the time factor involved, and ultimately what is going to be the outcome, whether by spending this kind of money, whether by spending this kind of time, is it worth getting back the outcome? So we must work out the litigation, work out this process, this balance sheet has to be worked out. The third we must do is, we must settle the claim by not only exchanging notices and also causing reply, but must see that if we can avoid the litigation. In this way, it is not only the cost, it is only the pendency which we were talking about could also get reduced. The next point is, we must settle through mediation before even we go to the court. These days, as rightly pointed out, that section 89 of the Civil Procedure Code, which encourages mediation and other alternative sources of adjudication of dispute, we must encourage pre-litigation mediation, which is very important. Because the litigation process is yet to start. I'm only talking about a situation by which we can avoid, we can hold on to the hands of the litigant, please don't go to the court. You are going to add up more litigation, the cost is going to be there, we can stop him there. There the role of the lawyers are very important. We must not encourage them just because they want to fight litigation. So pre-mediation is one process which must be utilized to the fullest extent. Then is the stage before we really file the case in the court, is to exchange the pleading and evidence before we enter into the area of litigation. While I was interacting with Prashant, he had a very interesting experience which he had while he was representing a client from India, probably I think with somebody from Australia, where he said that before even we could start the litigation process, we exchanged the pleadings, and this process not only helps us to know exactly the area on which we are going to litigate, maybe that there may not arise a situation for the court to frame issues on things on which already the parties have settled and have come to a finality. So maybe there are 1 or 2 or 3 issues. So the time framework which we normally spend, say months and years, can be reduced to weeks and months. This being the 5 bullet points, now the role of the stakeholders on which I wanted to speak.